ahead and get started. I want to welcome you to our training today on the Family First Prevention Services Act, or FFPSA, an update on QRTP placement reviews. My name is Rebecca Vandenhanen. I'm a staff attorney with the Children's Justice Initiative, the CJI program at the State Court Administrator's Office. And I'm joined today with Judge Janet Kane from the 1st Judicial District in Carver County and Judge Angela Wilms in the 4th Judicial District in Hennepin County. We also have with us today, and we want to welcome Judge Robin Millenacker from Ramsey County in the 2nd Judicial District, who's going to be sharing with us as we go through our training a little bit about her recent experience going through some QRTP court reviews and some best practices. And I also want to welcome and thank for being here some of our DHS, Department of Human Services colleagues who are going to be available for questions that may arise throughout the course of the training, especially those that touch on things from the social services perspective and some of the 4E reimbursement type related questions. So we want to thank them for being with us today. And do know that we might be looping them in and having them, provide some additional clarifications as we go through as well. So again, I just want to welcome you. Thank you for the information that you did provide to us when you registered for the training. It was very helpful in helping us understand who our audience was going to be and to really try to tailor this to some of the questions that we saw that you had or some of the supports that are needed and that kind of thing. So what you'll see up on your screen is just an outline of our goals for today. We want to provide you with just a real kind of quick and again, high level summary of the Family First Prevention Services Act and how it is impacting child welfare cases so that we're all on the same page. That's going to be a little bit of a review and update from our foundational training that we did last fall. We also want to circle back and spend some time talking a little bit more about qualified residential treatment programs, or QRTPs, because there was a lot of questions that we saw that people still had. The last time we did this, I know that a lot of these things were still in the process of coming into existence. And so we want to provide some updates where they are located, where you can find more information about them, that kind of thing. Same with qualified individuals, or QIs. We want to talk about some changes to the definition of qualified individuals, some resources that way. And we also want to talk to you in general about some new and existing resources that are out there to support your work. So we'll spend some time talking about that. And then also best practices from around the state that we've been identifying and gathering as far as managing cases involving a QRTP placement from all of our different stakeholder backgrounds. So we want to share and collaborate when it comes to how we are doing this work so far and what we've learned in the time that we have been working with QRTPs and court reviews. We do have some time at the end that we've set aside for questions. And so we would ask that you please hold your questions to the end. As I mentioned, we looked closely at what questions were submitted ahead of time, and so we've tried to really incorporate that into the training. But to the extent that there's certainly additional questions that come up or still questions related to those, we'll have some time at the end to do that. So feel free to unmute at the end, or if you put your questions into the chat, we're happy to read those and answer those as a group at the conclusion. And then I just wanted to let you know as well that we will be sending an email following this training that contains an evaluation, as well as a link to all of the different resources that we'll be talking about. So as we go through this, if you're trying to take some notes or wondering kind of where to come back to get to something, we will be sending a follow-up email that contains that information with direct links to all the resources that we'll be talking through, along with professional credit information for each of the different stakeholder groups. So do know that that is coming and that we will be following up later today with that. So to get us started, I'd like to just take us through a handout that we had referenced when we did the training earlier in the fall. It's a handout that we have available on QRTP placements, and it's on our public website. What you'll see on your screen is just a glimpse of what that looks like. And this training today and our foundational training we're really intended to walk through that handout. And so this is a great place to come back to for additional information or to guide you in your practice of these things. And so part of what we'll be sending in that follow-up email will be a link to this resource. And if you did save that or print that from our previous training, it has been updated as some of these changes and additional information has become known. So we would encourage you to, certainly bookmark the link or pull that up again, just to make sure that you're getting the most current version of this document. And it will continue to be updated as additional questions or issues come up. And so great place to come back to as we go through this. In addition to that, we do have a new guide to qualified residential treatment programs or QRTPs available also on the Minnesota Judicial Branch website. And so we will be sending a link to this as well. And this is something that goes into greater detail about QRTPs. And so this is a place that you can find additional information. It's really meant to supplement that, that handout that I had mentioned, that kind of front and back handout. Goes into more detail, some frequently asked questions that have come up and that sort of thing. So another great resource to take with you moving forward. So before we get into some of the kind of best practices and some of those pieces that we're really hoping to spend some time today talking about, I just want to bring us back to the Family First Prevention Services Act and just a high level summary of what it is and its impact on child welfare cases, just to provide that foundational, summary of that foundational information so that we're all on the same page. So what you'll see up on your screen is, again, just a summary of what that is. Really what it's about is primarily about keeping children and youth with families. And so a lot of the act, as its name suggests, focuses on prevention and getting resources to families early in the process to hopefully avoid entry into the child welfare system. Now, for families that do enter, it really prioritizes placing children with, keeping children with family in family settings or placing them in a family setting. For children or youth that are placed outside of that type of setting, there are some limits on that type of placement in a group care setting. And so that's what we're going to spend some time talking about today is those additional reviews and limits associated with those types of placements. So Minnesota, like many states, delayed full implementation of the court review requirements associated with the Family First Prevention Services Act, as you probably know, until September 30th of 2021. And so leading up to that, we have spent a lot of time talking with other states that have implemented earlier in the process or that we're going through implementation the same time as Minnesota to really brainstorm to find out what has been working or what other states are thinking through as they're contemplating the impact of this on their hearings and their court calendars, and how some of this is tied to their race equity work and all kinds of things like that. The deadline under the federal legislation for implementing this was October 1st of 2021. And so all states had until October 1st of 2021 to fully implement these court review requirements. Since implementation on September 30th, we've continued to be in dialogue with the other states, talking through questions and issues that have come up, and really using that too as a format to see what additional supports we might be able to provide to you and other stakeholders as we navigate some of these changes. And also as we think through what might be helpful as we continue working with this in terms of some of the data that we're collecting and some of the performance measures associated with this over time. So what you'll see up on your screen now is just a summary of what these new placement settings under the Family First Prevention Services Act are listed out. And these are all exceptions to the limitation on funding associated with children and youth placed outside of foster family homes. And what we're going to spend the majority of our time talking about today is really that first bullet point, the Qualified Residential Treatment Programs, QRTPs, because those are the new placement setting that involves a layer of court review that's new and different, and that most directly impacts the courts and the court process that we're going to be talking about. So as a reminder, a Qualified Residential Treatment Program is a new group care setting that meets federal and state requirements and is licensed and certified through the Minnesota Department of Human Services, or DHS. So as I mentioned, we do have some colleagues from the department with us today, and we worked closely with them through this implementation process because so much of this does touch on work that we each do. And certainly as we go forward, we're going to be talking a little bit more about their role in this as well. So now what you'll see is just a reminder of how qualified residential treatment programs differ from other placement settings. What makes a QRTP a QRTP? And so it is, something that has a trauma-informed treatment model, registered and licensed nursing staff that's available 24/7. It's something that meets Title IV-E requirements, as licensed and accredited by certain independent nonprofit organizations. Family outreach is a part of the child's treatment plan, and it provides discharge planning and 6 months of family-based aftercare support. So these are all things that really make this new placement setting very distinct from other group care settings. So a big question that we've gotten from people is, where are QRTPs located? When we did this foundational training on this topic in September of 2021, a lot of facilities were still going through the process of, applying to be licensed and certified. And so I think there were a lot of questions at that time and sort of following that about how many are there, where are they located? And things, as I understand it, are still in somewhat of a state of flux with respect to that. So the best place to go to find, real-time and accurate information as of the time that you're looking it up is the licensing information lookup tool on the Department of Human Services website. And what you'll see up on your screen is just a screenshot of what that tool looks like. And that would be a great place to look up and see if a facility has that licensing and certification as a QRTP. Also a place where you can look up and see if there's a facility that meets some of those other new placement settings that were created under the Family First Prevention Services Act as well. So setting, for example, specializing in working with pregnant and parenting youth. This is a great place to look for all of that information. And now I'm going to turn it over to Judge Kane to take us through the new requirement on initial court reviews of QRTP placements.
All right. Well, good afternoon, everybody. Just a reminder to please put yourself on mute. If you aren't already on mute, we're getting just a little bit of feedback. All right. You're asking yourselves, why as CJI teams do we really need to care about QRTPs, Qualified Residential Treatment Programs? Well, there's a couple reasons why we need to really pay attention to it and why we need to care about it. Number one, as judges, they have to make certain findings, and that if social services isn't getting the necessary information into the court is not going to be able to make the findings on time. And if the court doesn't do that, we can lose 4E funding. But even more important than that, what that means is that the court is not doing judicial review to really determine if this is the best placement for the child. And as we all know, it's really important that we have all of those checks and balances in place because we really all want to act in the best interest of the child. So this new law is requiring the courts within 60 days of placement to either disapprove or approve the qualified residential treatment program. And so what the court really needs to do is they need to make a finding of whether this placement is the most effective and appropriate level of care for the child in the least restrictive environment. It also has to be consistent with the child's permanency plan. And we also have to make a determination whether the child's needs can be met at home with additional services or in foster care with additional services. Because if the child's needs can be met at home with services or in foster care with services, then it is not appropriate that they be in a qualified residential treatment program, and the court should disapprove that placement. Now you're wondering, well, how do we do this? Okay, well, there's 3 different ways that the court can make these findings and hear these cases. They can either do it administratively. So in other words, social services could send in all of this information to the court and serve all the parties, and the judge can just make the decision administratively based on the paperwork. Otherwise, it can be combined with another hearing, whether it be an admit-deny hearing, a review hearing, a permanency review hearing, whatever it is, it can be combined with that, or it can be a standalone hearing. So it's just important to recognize that we can do it those 3 different ways. So what is the timeline and the process? Well, there's either going to be an actual or a proposed QRTP placement. If there's an actual placement, that's usually because it's an emergency placement. The child needs to be placed immediately. We can't wait. Other times it's being proposed. And so then what happens next is then the court services, or excuse me, court, I apologize. Oh, it's been one of those days. That social services needs to identify a qualified individual. And so you say, well, what is a qualified individual? Well, a qualified individual is someone that is culturally competent, they have the appropriate training, and that they don't work for the placement facility that is being proposed as the placement for the child, because clearly that could be a conflict. When we originally started this, they also indicated that it could not be a social worker from the agency. But now Minnesota has gotten a federal waiver to allow social workers to be able to be QIs. And so what I think they're trying to do in the Twin Cities is they're trying to get QIs qualified and registered with DHS, so that, let's say we have a placement in Carver County, that a QI or a social worker in Hennepin County can review the placement and act as a QI in that case. It certainly would not be best practice to have a Carver County social worker approve another Carver County social worker's placement. And you can see where there could potentially be conflicts of that. So certainly best practice would be a social worker from another agency. And I believe that all the Twin Cities social services agencies are working on developing that. And that's something that could be developed outstate as well. So really want to encourage you folks outstate that if you don't have a lot of access to Q qualified individuals, that you try to develop a roster with other social services agencies, at least in your district or in your area. All right, when ICWA applies, that in other words, when you have an Indian Child Welfare Act case, it's going to be really important for social services to notify the tribe as soon as possible. So if the tribe wants input, or if the tribe wants to pick the qualified individual, they can do that, because the tribe is a party if there is a CHIPS case. And so they have the right to go ahead and indicate who the qualified individual either should be or is. So just want to make sure that you've always got that in the back of your head. And so the next part of the timeline is once the qualified individual has been identified. Give me a moment. I apologize for that. I forgot to turn off my phone. All right. For the qualified individual, it is also besides having a roster and a list, is making sure that you check the DHS website if you have trouble finding someone, because DHS is developing their website so they have a list of qualified individuals, and also that they have that list of QRTPs. And obviously, as time goes on, those lists will get bigger and bigger and will make it easier for social services to go ahead and find these individuals. All right, so again, with the timeline and the process, you either have the proposed QRTP placement. Then the next thing you do is you identify and contact your qualified individual. That qualified individual has 30 days to do an assessment to determine whether this is the most appropriate placement for the child. And during that, they are going to be having contact, if there's an open CHIPS, with people like the guardian ad litem, potentially the child's family, social services, the permanency team, all of that. They're going to be getting all that input, and then they are going to be doing a report. Within 35 days, social services must file that report with the court. And then the court is either going to review it administratively, or they're going to review it at a hearing, either in combination with another hearing or as a standalone hearing. When you're asking yourself, well, gosh, how does the court find out about this? Well, DHS does have some court report templates that social services can use. Now, social services doesn't have to use those templates, but the one nice thing about them is we know that they contain all of the things that social services needs to cover and needs to do. And also at the top, they have a check mark, which notifies court administration that this is a QRTP review. They need to get it to a judge, and that the judge needs to review it and approve it within 60 days of the actual placement. And again, if the judge doesn't do that, you could potentially lose funding, as well as not acting in the best interests of the child. It's also important to note that social services, not only do they have to file this report with the court, but they also have to serve the remaining parties. Now, that does not mean personal service, excuse me. Social services just needs to get it to all the parties, and that would be the guardian ad litem, the tribe, if a tribe is involved, the child, if the child is over 10 years of age, and the child's attorney, as well as the parents. And social services needs to let all of the parties know that they have a right to ask for a court review in a court hearing. So in other words, let's say social services asked for an administrative review, any of the parties could request that the court review it at a court hearing, and then those parties, if they object to it, they can present their side. So it's important to know that due process is connected with this, so that all the parties, if they have concerns about it, have the right to be heard by the court. All right, in addition, the next phase of the process is, again, having that review hearing, and it will be in court review if the child requests it, at the court's discretion, if the guardian requests it, or if the parents request it, or if the tribe requests it. Otherwise, it clearly can be an administrative review. This is a point too where I really need to point out that you need to talk to your CJI teams, because we want to make sure that there's a smooth process for this. In other words, that court administration knows what to do with these QRTPs when they actually get them. In other words, passing them on to a judge. That the judge and their team knows what their responsibilities are, and that social services is correctly serving all the parties in the case, if there is a CHIPS or a permanency case, and making sure those parties understand their right to be heard by the court. I should note that these QRTPs can occur at any time. In other words, they can occur in a voluntary placement when there is no CHIPS. They can occur at the beginning of a CHIPS. They can occur at the middle of a CHIPS. They can occur at the end of the CHIPS. They can occur in permanency. So keep in mind, whenever a child, the proposal is going to be to put them in residential placement, as long as it's a residential placement that is a qualified residential treatment program under DHS's guidelines and registered with them, then you must go through this process. If, however, the residential program is not a program that is a qualified residential treatment program, you do not need to go through this process. Also, if your child was in a qualified residential treatment program before, I believe it was September 30th or October 1st, then they are legacied in. And what that means is the court does not have to review it within 60 days. In the future, though, it probably is a best practice for the court to be reviewing it. That way we get in the habit of doing that when they are qualified residential treatment programs. But just so you know, the kids that were in a QRTP before this took effect, they are legacied in, and you technically do not have to make those findings. All right, so again, what are the findings that a judge really needs to make? First, can the child's needs be met by their family with services put into place? Or can the child's needs be met in foster care with services put in place? If the answer to those two questions is no, then you move on to, is the QRTP the most appropriate, or excuse me, the most effective and appropriate level of care in the least restrictive environment? So the court has to make that finding. And also the court has to make a finding as to whether it's consistent with the child's short-term and long-term goals in the permanency plan. There also is a third finding that the court needs to make if the child is placed out of state. And this can especially be true if the child is a real special needs child, or the child has been in multiple placements, that social services may be considering an out-of-state placement. Or you may be in one of the border towns in Minnesota, where a lot of times your placements out of state are much closer to the family than maybe an in-state program. So at that point, it's really, it's necessary for the court to find compelling reasons as to why the child is in that out-of-state placement. So let's just say you do live in one of those border towns, and let's say you decide to place the child, or social services decides to place the child in a qualified residential treatment program right over the border. Well, what would some of those compelling reasons be for the court to make that a finding? Well, it may be that that program is the most appropriate for them. It may be that it's closest to their home and allows the parents to participate in family therapy. It may be most appropriate because it allows the child to go home on home visits, which is close by. There may be a whole variety of things, but I just want you to keep that in mind, that if the child is placed out of state, there must be compelling reasons. Also, at the initial review, it is important to understand that children under tribal court jurisdiction, you still have to make the same findings, whether or not there is an affiliation with a tribe. And so those court requirements do all apply to all juvenile protection proceedings, regardless of whether they're 4E eligible or not, regardless of whether they're ICWA or not. So just make sure that you're understanding that we have to make these findings in all these different circumstances, as long as it's a qualified residential treatment program, and that needs to occur in 60 days. The other thing is there needs to be a written order. So while it's certainly fine for you to indicate on the record that you're making these findings, it also needs to appear in a written order. And again, this can be a standalone order when you've done it administratively, or it can be a standalone order if you're only reviewing the QRTP in court, or it can be in an order that you've combined with some other hearing, whether it be an admit-deny hearing, a review hearing, or whatever. But you must make sure that your findings are in writing as well. All right, and at this time then, I am going to turn it over to Judge Wilms.
All right, thank you very much, Judge Kane. So we're going to talk a little bit about the findings that are going to be necessary for ongoing court reviews of QRTP placements. And much of the findings, or many of the findings that a court would need to make, are similar to what Judge Kane just talked about for those initial placements. So things shouldn't be too different overall in this section of the training than what you've just heard, but there are a few things just to keep in mind. At these additional reviews, it's important to remember that under 260C 712, as long as the child remains in a QRTP placement, the agency is going to have to submit at every hearing or at each administrative review or court review or permanency hearing enough evidence for the court to make these findings that are listed here on the screen. The court's going to have to make an ongoing assessment that confirms the need for residential treatment. The court's going to have to do that by evaluating such things as the out-of-home placement plan, the specific treatment or services that are being offered to the child to determine whether or not those services are appropriate to meet the child's needs, the length of time that the child is expected to need additional treatment. So essentially overall to examine how much time treatment needs are going to take, whether treatment is appropriate for the treatment needs that have been identified, and whether these treatment services overall are efforts that are going to improve the child's ability to eventually be placed in a more family-like setting. Overall, we want that for the children, and that's kind of what the goal of these reviews are, to make sure that the services are appropriate to meet that goal. For out-of-home or for these QRTP placements that involve placement in a QRTP facility that's out of state, as Judge Kane talked about, we are also going to need to be making a finding as the court, whether there are compelling reasons for the child to be placed out of the state. And again, as Judge Kane said, there are probably going to be many instances where an out-of-state placement may be closer to the family than an in-state placement. And we would need to just make that compelling reasons finding before approving a QRTP placement out of state. So we also need to review as the court essentially whether the agency head has approved an extended QRTP placement. And so what we mean when we talk about extended QRTP placements, we define them as having more than 12 consecutive or 18 non-consecutive months for a child that is age 13 or older, or 6 consecutive or non-consecutive months for children younger than 13. So we have an age division, which obviously is a fairly common thing now that we've seen in child protection matters, where we separate our reviews by age. But we do this essentially to review whether whether a QRTP placement qualifies as one of these extended types of placement. The thing that's important to remember here are that when we're calculating what it means to be in an extended placement, it's not specific to just one QRTP placement. We're looking at the number of QRTP placements as a whole. So it would be the total amount of time in any QRTP placement. The only exception would be those children that are currently placed in what we would consider a legacy placement. So placements that qualify as QRTP, but the children were placed there before we made these statutory changes. So those legacy children are not necessarily, those legacy placements, I should say, are not necessarily part of this QRTP calculation for an extended placement. One other thing to remember is that if a child is a legacy placement and then is later placed in a QRTP placement, the time for extended placement would then start to tick as of the date of that second placement. So if you move from a legacy placement to a non-legacy QRTP placement, then you would start calculating time for that extended placement. Another issue to remember is that if the child moves from one QRTP placement to another QRTP placement after that, it's not considered, it would still be considered part of a consecutive time calculation. So I know some of these things seem a little bit muddled and confused, and I'm sorry for that. The thing to remember is that if your child is currently in a placement where you haven't started this review process and then moves to a placement where that qualifies as QRTP, all of these requirements would start to apply and you would start to calculate the time and the number of placements. So essentially that's what we're looking for when we're talking about extended QRTP placements. All right, next we're going to talk about what about 260D voluntary foster care for treatment cases. So before the FFPSA applied to our state, previously what would happen is that petitions for 260D cases would be filed with the court, and the court wouldn't necessarily have to have a placement review. We would be notified within 165 days of the placement, and we'd have that initial review with the court around the 175-day mark. The FFPSA is going to create this additional requirement, or it has created this additional requirement, where cases starting September 30th of 2021, cases involving a QRTP placement now need to be reviewed within 60 days of the QRTP placement. So essentially what this means is that we're going to have one additional court review prior to when we normally would have had it before. And it's the agency, of course, is going to be responsible for notifying the court when there's been this QRTP placement, and the court is going to be responsible for making sure that the review happens within 60 days of placement. So not all 260D cases, of course, are going to involve QRTP placements. So that's one thing to remember. Just because you have a 260D case doesn't necessarily require that you start these QRTP reviews unless there is in fact a QRTP placement. It's also important to remember here that QRTP placements can occur in voluntary placements. And those voluntary placements, of course, are handled under 260C 227. So it's important to remember, just on a broad scale, that QRTPs, those placements can happen under 260B cases, which are delinquency, and we'll talk about those in a moment. 260C cases, your juvenile protection cases, but also voluntary placements. And then the 260D cases, voluntary foster care for treatment cases. So just from a perspective of kind of keeping these reviews on your radar, it's important to remember that if there is a facility, a QRTP placement, you do need to make sure, regardless of the statutory authority for the placement, that we're all engaged in conducting these reviews so that the placements don't lose funding. It's also important, just I think specifically from agencies that are filing documents with the court, to indicate what the placement authority is for that particular placement. So if we're talking about 260B or 260C or 260D, and the reason is it's important for the court to know what the placement authority is so that we can follow the proper procedures when we're trying to route these cases for reviews. So in the next slide, you'll see that the reviews that we're talking about here can be done administratively if needed, and an order can issue without a formal hearing. So in many cases, it makes sense to have these reviews be conducted as part of your regular course of business. So if you already have a hearing scheduled, it makes sense, obviously, to conduct this review as part of that hearing. But if for some reason you're not able to do that, or if the parties are in agreement with handling it differently, for example, you could issue an order as a court without conducting a formal hearing. And then in 260D cases, you would just be subjected to the normal review requirements that were previously in place for these cases, and those are listed on this slide. Okay, on the next slide, we're going to talk about delinquency cases. So the main thing I want to highlight for delinquency cases is just a couple things. First of all, there probably aren't going to be very many QRTP placements for delinquency cases because there are few contracts with corrections agencies that involve 4E. There of course are, though, a couple of those placements, so it's just important for those to be on everyone's radar, especially for cases that involve QRTP placements through the social services agency. So if a delinquency case has tied into the social services agency, it's just important for that to be on everybody's radar. All of the normal review requirements would apply for delinquency QRTP placements, and that if and when it applies, the agency, the responsible or applicable agency, is going to notify the court and request the review. And the review can occur with an order issued approving or not the placement within 60 days of placement. So once again, these can occur administratively or as part of your normal course of business. And it's important just for people to be discussing this so that it's so that everyone knows who's responsible for notifying the court, and that the court can make sure to understand that this is in fact a case that requires that type of review. So overall, we'll just be talking a little bit about why court review is necessary. You've heard Judge Kane and I talk about this a lot, why it's important to ensure that we do these reviews predominantly to make sure that we don't lose funding. But the more humanitarian reason, I think, for us to conduct these reviews has to do with ensuring that our children and our communities are placed appropriately and that they're not stagnating in those placements, so that we're making sure that treatment needs have been specifically identified, that the placement we've selected is in fact meeting those treatment needs and has an estimate of how much longer that will take, and that we're making sure that this is appropriate for the child, and that it will likely be successful to return them to a more family-like setting. I think we all know, those of us who have been involved in these placements, that sometimes they can be very hard and very traumatic for kids. So it's really important that we're ensuring that this is the right place for them to be, and that we're on a path to have them released or moved from that facility as quickly as we can. So next, we'll talk about best practices overall. So we haven't had many of these because it's still early in the process, but we have learned a few things. First of all, it's really important for stakeholders to just be having conversations amongst their CJI teams to make sure we know how social worker reports containing QRTP assessments will be filed in our particular counties, to determine the extent with which social services in each county will communicate information from parties and request hearings, and just to understand the role of the guardian ad litem amongst different districts and whether there will be changes to any reports or practices in response to these new court requirements. Overall, I think we've learned that there may not be many changes with respect to guardian ad litems, but I think the most important thing for best practices is just to remember that we all need to stay in good communication with each other so that we can address any issues that come up as we're transitioning to this process as quickly as possible. We haven't had, also it's important to note, I think, that we haven't had many of these reviews because the Department of Human Services is still working on licensing qualified individuals, and QRTPs are still applying for licensures as that to receive that designation. And then, as I mentioned before, with legacy placements, there's a certain number of children who were in these placements already and who will not require these ongoing reviews until they move to a new QRTP placement. But we do have a judge.
Hello.
Oh, I'm sorry. I think someone's unmuted. Okay. We do have Judge Millinacker here from the 2nd District to talk to us a little bit about her experience conducting QRTP reviews. And so Judge Millinacker, I'll ask you if you could just talk a little bit about that experience, and if so, kind of tell us under what statute or what general statute you reviewed your cases under, and any other information you'd like to share with us today.
Sure. Well, thank you. It's nice to be with everybody. Yes, I've handled 2 cases administratively here in Ramsey County, the 2nd Judicial District, meaning there were no hearings on Zoom or in person. One case involved a 12-year-old girl and the other involved a 16-year-old teenage girl. Both had multiple suicide attempts. I reviewed the reports based on the templates that were filled out by the qualified individual, which in each case was a social worker from the Department of Human Services with no connection to Ramsey County. I looked through their assessments and their recommendations. They contained what prior efforts had been made, what community-based services. Both kids had partial and full hospitalizations. The reports contained family interviews and interviews with the kids. These 2 cases that I handled, each of the kids was unable to maintain their safety or utilize the skills that they learned from previous services once they were out of their structured settings. And both kids needed 24/7 supervision. The social workers report argued that there was no less restrictive alternative settings to maintain the safety of these kids, while also providing mental health services and to help the kids address their underlying issues and behaviors. Now, the requests that I received were for longer term services in a setting with 24/7 supervision and intensive services. And as I said, many other things had been tried, and each of the children could not be returned home or to foster care or to their adoptive parents. One of the teenage girl, the 16-year-old, was actually a refugee. She grew up in a Thai refugee camp and had multiple traumas that she was dealing with. The 12-year-old got placed in a facility in a treatment center in St. Cloud, and the 16-year-old was placed in a program in Blaine. So still here in the metro area. And once I looked at all of the reports, the county attorney actually sent a draft order to me, which I reviewed, amended, and signed. And both of my cases were under 260C.712. And the parents were very cooperative and supported the placement. So that's it.
Judge Millinacher, one of the things I forgot to mention in the slide is that when the social workers are submitting their reports to the court, they have to have the updated out-of-home placement plan. They have to have the QI's assessment and either a request for a hearing or a request for administrative review and any of the other information from the parties. Did the social worker do all of those things in your case?
Yes.
Okay, great. And so you did have the placement plan, you did have the QI's assessment, and then the social worker had also notified all the parties in the case so that they could challenge it if they wanted to and request a hearing?
Yes.
All right, excellent. So it sounds like they did exactly what they were supposed to do.
Yeah, it was really helpful to review the out-of-home placement plan and the qualified residential treatment assessment and recommendation.
Okay. And Judge, go ahead. I apologize.
No, I was going to say, and as I said, both sets of parents were supportive because they were at their wits' end.
Okay. And did you guys discuss at your CJI team, or how did your court administration know how to handle these cases when they came into you?
Well, that's a good question. I know that our court admin is in touch with Judy Nord, as is Judge Hilgers, and they're on top of the CJI developments. Okay.
So at some point, your team must have discussed it with them, or social services must have informed everybody on your team. Okay.
Yes.
Great. Did it seem like it was a fairly seamless process, or were there any obstructions or roadblocks that you kind of ran into that was like, ooh, what do I do now?
No, none whatsoever.
Okay.
It was a very streamlined, easy, smooth process.
And I assume that if one of the parties or the social services would have requested an in-person hearing, then your staff would have just made arrangements for court administration to get that set on with another review hearing or a standalone. Is that fair?
Absolutely. Yep.
Okay.
Yeah.
Awesome. Well, glad to hear that it went fairly smoothly, because like we've said, there's been so few of these that we just don't, I know I haven't had experience with them, and Judge Williams hasn't either. So it's so helpful to hear from someone that has actually had this experience.
Yeah, it worked really well. And I'm so glad, because it really worked in the best interest of each of the children.
Awesome.
Thank you.
Thank you.
Thank you. We'll turn it back over to Rebecca now.
Thank you. I will take us through just a quick summary of some additional resources. We talked about a few of these things, but where you can find these pieces of information and additional resources as they become available, a great place that you'll see on the left-hand side of your slide is the Family First Prevention Services Act help topic on our website. If you click on that, you'll find categories of information. That's where the recording of this training will be located, along with all of our other handouts and materials. And then on the right-hand side, you'll see just a email address that you can use to our CJI program. And this is a great way to reach out if you do have questions, additional issues or questions, things that you're navigating as you continue to work with this. That's a great way to reach out to us. And now what we'll do is open it up for questions that people may have submitted here. Feel free to unmute or put your question into the chat if you haven't already done so.
So there's one question in the chat. Well, there's a couple, but there's one in particular that says, since we typically don't file a petition for 260D voluntary foster care for treatment cases until close to day 165, will we run into issues filing a new case for QRTP documents without a petition? Or should we be filing our petitions with those documents within 60 days? And Becca, I guess I'll turn it over to you in case you have any, I don't know what the state is doing in terms of that.
Yeah, I can go ahead and answer that. The expectation is not that there would be a petition that would need to be filed any earlier in the process. But that's where, when that filing is made, because there isn't already a court file that's been created, it's really helpful to make it clear at the filing what type of file this relates to, so that court staff, when they get that, know this is a new 260D case, and that's how we're going to open this and track this, and then it's subject to all those same requirements as it moves forward. And the reason for that, like we talked about, is because voluntary placement agreements can come up in the context of a 260C case as well, where there's already an existing case. So by sometimes just seeing the voluntary agreement, we don't necessarily know which case type it is. So the more clear it can be by citing to the statute, the 260D, in the out-of-home placement plan, in the request for the review of the QRTP placement, the assessment piece that gets filed, the more helpful that is. But no, there wouldn't be an expectation that the petition come in at that stage.
All right. There's also, I just want to confirm with Chris Johnson, because there is a lengthy question here in the chat about the 12-year-old requirement, which I think refers to extended QRTP placements. I think that maybe the response to direct that question to DHS was referring to that question. Is that correct?
Exactly, because it's the cans can be completed in children younger than 12. So, but the best is just to reach out to our staff. This email address is staffed by our QI and QRTP experts, so they can easily answer the question. So just send that question to us and you can get an answer back. So, and if you want a consult, we will also schedule a consult with the county as well. So.
Okay, thank you very much.
You're welcome.
The next question is there a notice that the social worker provides to the parties for them to know that they can request a hearing? How does the court know everyone has been notified that they have the right to request a hearing?
Again, this is probably something I would recommend, Rebecca, unless you have any better advice, is that you discuss at your CJI teams. So everyone is really clear. Normally, if you've served the other parties, social services would do an affidavit of service indicating, or a letter indicating that they had served all the other parties, and that would be filed along with the QI report, the out-of-home placement plan, et cetera, et cetera. But Rebecca, do you guys, from CJI standpoint, do you have any best practices that you're using?
We don't have any, I guess, specific guidance on how that occurs. I was a little curious, just in thinking with our DHS colleagues, if they've issued any specific, guidance as far as how that communication happens with parties about some of those rights. But my sense is that could be an area where there's some variation. And so having that conversation with your CJI teams is what we've been encouraging, just so it's clear kind of how that occurs, and how if if somebody learns that maybe there is some disagreement or that there will be a request for hearing, if that's something that gets communicated at all through the social services agency, or if it would just come directly from that party, that kind of thing. But does anybody from DHS have anything additional to add on that point?
I can talk to that, add a little bit to it. This is Paul Meinhardt. The QRTP template that is in SSIS, the court report template for a QRTP does have in it a question of have the parties been informed of their right to request a hearing? So how the court would find out is it should be included in the court report that's being provided to by the agency. And again, 260C.71 really lists the elements to include in a court report. Those are covered in the template on SSIS, but if the agency is using their own court report, they should build that report off of 260C.71 in addition to the rules. But that's really for the QRTP, and it's an element of the court report. So that's how the court would find out. What Rebecca and Judge King, you were talking to earlier about, how does a party actually make that, if they want the hearing, how do they make that known? And again, it's on the agency to make sure that the judge is aware of it if a party is expressing to them that they want to have a hearing.
All right, and then this also may be a DHS question just about broader statewide discussions. It looks like this question has to do with these higher standards of care that QRTPs now have to qualify or follow. The questioner said that there was a belief that these would apply to all residential facilities and that there was a discussion about that. At this time, obviously based on our training, these standards and review are only required for QRTP placements. But does anyone else have any information from the state about that discussion or that broader discussion?
This is Deb Beskey-Brown, and I can just add that the requirements for the QRTP process only apply to those facilities that have that certification. And there is not any requirement for other facilities to meet those requirements. I will add, though, that the other thing that FFPSA did was identify new specific settings for very specific issues that children and families are dealing with. And you had that on your first slide, which includes sex traffic and PPY, and also then a supervised setting for 18 to 21. I will also note that those don't require this assessment and additional work, but it also allows for the federal participation through Title IV-E for those settings, no matter how long the child is placed there. And I believe there was a question earlier about barring other residential facilities from Title IV-E, from the agencies to claim Title IV-E. And with those new specialized settings, we have many that are now certified for sex trafficking. I believe there's over 20. So being aware that while it does limit the Title IV-E ability of agencies to claim for residential placements, it did add new settings, specific settings to meet children's very specific needs. So I just want to point that out as well. But other facilities can have 14 days of claiming. All Title IV approved facilities can have 14 days of claiming. I hope that helps clarify that.
Yes, thank you.
And I would just add, sorry, that facilities get to decide if they want the special certifications. So they apply to our licensing division, then they go through the certification process. And so if they are a QRTP, then it applies to all the kids placed in that facility, regardless. Someone else said earlier, regardless of the status of the child, if the child's 4E eligible or not. But counties can, and the tribes can, continue to place kids in residential treatment facilities, or what we call congregate care facilities, that are not certified QRTP. But in those cases, there is no federal reimbursement for those places. So in order for counties and the tribes to receive some federal financial support, they have to place in certified QRTPs.
All right, thank you. The next question has to do with whether a parent who is a participant under court rules and not a party have the right to request a hearing. Is it discretionary for the court to hold a hearing on participant parents' request? And I think this question is going to depend on a parent's right to be heard under the different statutory subdivisions. So under 260B, for example, if a parent is attending a delinquency proceeding, the parent can be heard in the best interest of the child with the court, of course, because the parent can be a party to those proceedings, and we don't necessarily dive into their custodial status. So that's one aspect, at least. For 260C, of course, we'd have different considerations. The parent would be the non-custodial parent. If it's an alleged parent, for example, would have the right to be heard in the best interest of the child if with court permission, but not necessarily a party and have the ability to request a hearing. And then under 260D, the parent would have, it depends again on the status of the family, but the parent would have the ability to request hearings. 260Ds are just a little bit different though, because many of our reviews are administrative, or that initial review could be administrative. So I don't know, Judge Kane or Rebecca, if you have any other information on anything I just said or clarifications to that.
Go ahead, Rebecca.
I was just going to say that I think that's a good summary. And I think they certainly have the right to request it. And I think, kind of the decision of the court to, take that information really kind of depends on what Judge Williams had talked about. And, because of their role is a little bit different than being the party as, they're the participant instead of the party in the case.
And honestly, I think as a judge, you would have discretion, even if they're technically not a party, if you were willing to grant a hearing. We can always grant a hearing in our discretion. So if we want to have a hearing, we can do that and we can allow them to be heard. But again, if they're technically not a party, I don't think you have to do that, but it's in your discretion. Do you think that's fair, Rebecca and Judge Williams?
Yeah, I would agree with that.
Yep. Yes.
Sometimes there's a little bit of a clarification under 260C in terms of how the parents are acting if they've been placed on foster care, for example, because foster parents would have a right to be heard. But if that's not an issue, then I don't think there's anything else that would require a hearing for a participant. Okay, so the next question has to do with whether the review, I believe this might be for 260D cases, does day 175 court review, does that have to be in person for QRTP, or can it be done administratively? The QRTP requirements, and Rebecca or Judge Kane, correct me if I'm wrong, but I believe the QRTP does not necessarily require a particular type of hearing, whether that be in person or administrative. It just adds additional things that we would need to review when we're conducting a review, whether it be administrative or otherwise. But the statutes, the other statutes that may apply to a case may require particular types of proceedings, a formal hearing or an administrative review. All right. And I think some of these are directed to other people. So I believe that's all the questions that were in the chat. If anybody else has any questions, you can please unmute and let us know, or include additional questions in the chat. All right. I'm not seeing any questions at this time or hearing anything. And so I just want to thank everybody for taking the time to learn more about this process today, and for listening to us as we learn new things about this process while we do the training, I think just about every time. And so it's nice to be able to get input from the people who were able to attend today, including Judge Millinacker, so we can all kind of learn as we grow together. Rebecca or Judge Kane, anything else?
I just want to thank our DHS people for answering some of those technical questions as well. It certainly takes a village, and so we appreciate all the resources we have. And don't forget the resources that are listed in the PowerPoint as well, because they are extraordinarily helpful. And if there's any judges that are at this training and missed the training that was specific to the judges, we have different resources for you. So you can contact Rebecca, myself, or Judge Wilms, and we can get those judge-specific resources out to you.
Yes, thank you. And please feel free to continue to reach out to our program if there's new questions or issues that come up.
Yeah, and I've said at previous things, I think a lot of times people are so used to getting a hold of Judy Nord, but Rebecca now is the guru on this. So if you contact Judy Nord, she will refer you to Rebecca, or you can just contact Rebecca directly or email that CJI email as well. And they're more than happy to answer any of your questions. And Judge Wilms and I are also more than happy to answer any questions you have if you want to email us as well. So thank you all very much. We appreciate you guys listening. And as Judge Wilms said, we'll all continue to grow and learn together. So thank you. Bye, everybody.